and welcome to ME-Arcone Queuing, platform dedicated to meaningful conversation based on alternative dispute resolution. And we are delighted to have you with us today, sir. And Me-Arcone Queuing, we promote peaceful, efficient, and collaborative dispute resolution methods to reduce the unnecessary burden on the courts. On the one side, when the courts play a crucial role in delivering justice, on the other side, the courts are overburdened with the cases. But what could be done alternative? We have ADR. We can use the methods such as mediation, arbitration, conciliation, and negotiation to resolve a dispute outside the traditional litigation system. In Me-Arcone Queuing, we call the ADR professionals to we can get the experience, expertise, knowledge which they perceive, which can be given to the audience, so the audience can be benefited through the ADR professionals' experiences. Before we begin, a brief introduction from my side. My name is Asa Sen. I am a final year law student from Kritsu Jayanti College of Law, Bangalore. I am also an intern at Institute for Alternative Dispute Resolution. It's a pleasure to have you with us today for this podcast, sir. Today we
Thank
have
you.
with us, thank you, sir. Today we have with us Prasad Subanna, sir, an accomplished advocate with over 40 years of distinguished practice in civil, family, property, commercial, check dishonor, and bail matters. Widely recognized for exceptional drafting skills underpinned by an innovative, precise, and strategic writing style that transform complex legal concepts into clear, persuasive, and legally robust documents. Extensive expertise in conveyancing, including the drafting, vetting of lease deeds, sale deed, gifts deed, agreements, rent agreements, power of attorney, title verification, and tracing for loan purposes, authentication of title deeds, partnership deeds, etc. Possessing over more than 18 years of experience as a qualified senior mediator and master trainer, certified by the International Center for Alternative Dispute Resolution and the Karnataka Judicial Academy in association with the Institute for the Study and Development of Legal System, San Francisco. Accredited as a commercial senior mediator by the Bangalore Mediation Center in collaboration with Judicial Arbitration and Mediation Services and the Foundation for Sustainable Rule of Law Initiative, United States. Empaneled master trainer for prospective mediators, approved by the Mediation and Conciliation Project Committee, Supreme Court of India, with a proven record of conducting numerous mediation training programs for judges, lawyers, professionals, and students across multiple states, including Maharashtra, Goa, Rajasthan, Delhi, Odisha, Kerala, Andhra Pradesh, Bihar, Jharkhand, extensively throughout Karnataka. Participants have included senior advocates, High Court judges, which includes Chief Justice and High Court of Karnataka, and members of the subordinate judiciary. Since 2008, Sir has successfully conducted over 100 training programs, fostering excellence in mediation practice and contributing significantly to the growth of alternative dispute resolution in India. With your permission, sir, shall we begin today's conversation?
Please.
So, our today's podcast is based on our theme technology and online mediation. Sir, when we see that India is evolving and also the new laws which have been brought up in India, they have included that electronic and digital platform in everything, which includes mediation also. So when we talk about
Correct.
mediation, how has the technology improved the process of mediation in resolving disputes online?
See, until the advent of the pandemic, coronavirus, we were not even having access to the courts by video conferencing. Due to the nature of the pandemic, the court then decided that the advocates could appear through video conferencing and the already overburdened docket should not be further exacerbated by the pendency increasing exponentially. So that sort of eased to some extent, the cases being conducted online, and at that point of time, many glitches were found, because most importantly, we must have an uninterrupted and steady internet connection. So some of the places we could not get. So we started working on that. Now, as we started working on court appearances through video conferencing, by then mediation was a very established platform. And in many of the major metropolitan places, hundreds of matters are being handled on a daily basis. So, when that being so, we also thought, why can't we extend this facility for conducting mediation? And gradually, we started conducting mediation, and especially when the parties are not in the same city. Now, that is where, if somebody is stuck in some place and they say, sorry, we cannot come to the mediation center. Now, instead of simply giving adjournments or dates, we used to tell them that, why don't you appear online, and still we can have a meaningful dialogue. Now, that is how that started. Now, once that started, the other this thing was, see, in a face-to-face mediation, what happens? Confidentiality is one of the most important things in mediation. And it is so confidential that what is discussed in mediation cannot be shared even before the court. Neither parties can use it before the court. Now, in a face-to-face mediation, we know certainly that the parties are not recording the proceedings, and especially when we have private sessions, we ask the other party to wait outside. Now, that was another challenge for us, as to how do we ensure that the other side is not listening to the conversation that we are having. So that is where all these waiting rooms, the virtual rooms, all that started. As a matter of fact, I would like to share one experience of mine where I conducted an entire training program for judicial officers. Hmm. And that was totally conducted on online platform. And participants had joined from Maharashtra, Goa, and Kerala. And I was in Bangalore. And we very successfully conducted, including, conducting role plays. I mean, that was another biggest challenge we always face, how to conduct role plays. So, to a large extent, what happened was that we could at least, connect with the people. See, that is where the ODR platform and the online virtual platforms, came to our aid. So, certainly, yes, the technological advancement and its implementation in the process of mediation, I would say, has definitely helped many people.
Yes, sir.
So, I mean, it's a very good thing, but even then, at this point of time, we still have to ensure aspect.
Yes,
And
sir.
of course, there are certain other aspects which, during the course of our conversation, we can touch upon.
Yes, sir. Yes, sir. Like, sir, as you said, that when mediation is conducted online, it can be cost effective also and time effective for the parties. So wherever they are, they can join it. If
True.
due to some health reasons, if they are not able to come to the mediation center, so instead of the depriving them from
Center.
the justice, giving the dates, it's better to call them online and have the mediation. So, as rightly said, sir, follow-up question when you talked about confidentiality. So, how
Very
does
true.
yes, sir,
Yeah.
how does in online mediation ensures privacy and confidentiality? Am I audible, sir?
See, just for the, awareness of the general populace, A mediation process generally starts with the opening statement and introduction of the mediator, and then the introduction of the parties, and then we go into what is the nature of the problem. All right. Now, what we have seen is majority mediations come from the matrimonial side, and the next one is the partition suits between siblings. Now, matrimonial issues are very sensitive in nature, more so if it is involves children. So custody of children, visitation rights, all these issues have to be addressed. There could be multiple cases between the parties. All right. So what happens in a face-to-face mediation? We know for certain that the parties express themselves freely and frankly without any inhibitions. And also, we can even decide as mediators as to who would sit in the mediation room. So we have control over the process as well as the people. Now, let us say the same thing on a virtual platform. Now, we would not know who else would be sitting in the room. I mean, the physical room where the parties are sitting, and they have joined the online process. Now, somebody else could be sitting right opposite to that person and maybe making gestures and signs or showing some, terms and conditions. Now, that is something which is beyond our control. At the same time, even if it is not being recorded and if we can control it, how to ensure that somebody sitting opposite to that person cannot just switch on a phone and start recording what is being told? Because see what the very difficult situation, what happens is sometimes mediation could be used as a platform to know what is the the terms that is sought by the other side. Now, in the court, we would not be disclosing that. It will have its own procedural aspects, where evidence, cross-examination, and all that. Now, in mediation, when they tell the terms, now they tell it to the mediator. Now, mediator keeps those terms with himself or herself and calls the other party and asks them what are your terms and conditions. And then it is what we call as, it's like a shuttle diplomacy. We move from one person to the other person and we carry the proposals and the negotiation gets concluded. And eventually, if it resolves in a settlement, then there is no appeal and it is beneficial. Now, coming back to the ODR platform, the risk factor always we find is, as I said, how do I know if somebody is not in that room? I cannot see. It's only a word of honor. They're saying that no, nobody is there. I'm sitting alone here. So that is one risk factor. Influencing. Now, influencing is something that happens by normally very close relatives, would be parents or other members of the family. The person who has come for mediation may have made up their minds, but they will still be swayed by the pressure from the relatives or somebody else, and they would say, no, you should not agree for this. Now, once again, on an ADR platform, I would not be able to find out if that is so. Okay, this is like, like teleprompting. If somebody is opposite to me and showing me what I should talk, it's as simple as that. But how far and to what extent we should always use this? See, now we have found that, for example, there are different time zones. Now, because of various reasons, employment or education or something, one party may be in some other country, and we have to keep in mind the time zones. And one of the parties may be locally situated. but they have a problem. They have approached the court, and the principal person may be represented by a power of attorney holder. All right. In such a situation, we have to accommodate that person's need, the need to address what he wants. Now, that could be done. See, instead of asking that person that you travel to the place where the mediation center is there or mediation takes place, because we do a lot of private mediations also. So instead of asking those persons to physically come, we can say you can join on this and we can take it forward. Only when the stage of settlement comes, at that point of time, maybe you could come to the concerned place, and then the settlement could be placed before the court for passing a decree, whatever may be the subject matter. Now, this aspect becomes very important in matrimonial and especially partition suits. Now, there are commercial aspects, commercial suits. Now, if it is a recovery of a sum of money or some terms and conditions of a contract, now it is a contractual based and there is no passion involved. Parties are dispassionate, they just want to resolve instead of waiting for a court to pass a decree whenever the time permits to the court. So there, it may be much easier to understand what the parties need. Now, see, world has become like a global village. The access because of technology is very easy. So we have to make use of that particular advancement of technology. Okay, so it is saves a lot of travel time and the uncertainties. Now, let us say a person comes and for various reason, the mediator is not able to attend to the mediation on that particular day. Now, what would happen? See, it could be rescheduled, of course, but at what cost? The person will feel, I traveled all the way and for nothing. Now, here what happens in the event of a mediator not being able to join on a particular date for various reasons, either personal or professional or whatever it could be informed to the parties. And they will be told that, see, for some reason, we are not able to join today. Would it be convenient to join on some other date, which is convenient to all persons concerned? Now, the other thing we have to remember here is, in our country, it is still court annexed mediation. Even though the Mediation Act has come, the rules are not yet framed. The Act came in 2013, 2023, but the rules have not yet been framed. So the court is the ultimate place where the orders would be passed. Okay, so in such a scenario, we have to ensure that the parties get what they want, because it's like there is nobody winning or nobody losing. Both agree to a terms which is mutually acceptable. So in that context, I would say that commercial types of matters are much more easier to mediate on an online platform compared to matrimonial or partition suits. Now one could ask, okay, what is the difference? See, as in a face-to-face mediation, we have the advantage of watching non-verbal communication, which is most essential. See the eye contact, body language, the gestures. Okay, we can read a lot from those. When somebody is appearing on a screen, it is very difficult to make out what exactly the emotions are emoted by that person. Okay, a small gesture may be missed. Okay? So, in sensitive cases, I would still suggest that a face-to-face mediation is more effective than you know, virtual mediation. Of course, time, cost, etc. If we think of this, that's good. But once again, do they have the facilities to join? You know, I
Yes.
mean, we have to think of even remote places. We can't just think of the metropolitan place, even remote areas. That is
Yes.
where some of the challenges we still face. You know, this is like many a times we don't get signals on our mobile in some places. Okay, then what do you do at that time? Nothing. You have to go to a place where you get signals. uh,
Yes.
so you can't be moving from place to place to get one signal. uh,
Yes. True. True. So, so you explained the online mediation so nicely that my questions, which I was having and I was about to ask, you answered already, like advantages and disadvantages of online mediation. As you mentioned that it
yeah.
includes the, if it is remote area, people might not be having the facilities to do the online mediation. That could be the
Correct.
one of the disadvantages. So, sir, my
Yeah.
concluding question is, as a mediator, what challenges you face while conducting online mediation?
Okay. See, primarily, the first challenge I face is whether the parties are participating full-heartedly. So there is no way for me to make out from their expression, all right, which in a physical mediation I can easily make out. Okay. And many a times people do not give importance to how they appear. Okay. So there what happens is, many a times I have faced the situation where, I can see on the background, a clothes line with all kinds of, clothes being hung, uh, and the party appearing in a dress which may not be appropriate for an official meeting. Okay? The same does not happen in a physical mediation. I mean, they cannot come like that. And we have our own setup where, it is a professional setup. All right. Now, that is one thing which, makes us feel that how do I go forward with this? Now, if you tell something, then it may be taken in the wrong sense. Okay, they might say you are like trying to point out some lacuna, even though I may be right, but they may misinterpret it and may not be in sync with what is the way in which a person should present himself or herself. That is one thing. The other challenge is that the attention span, more so when we put them in the waiting rooms or virtual rooms and say, I'm going to have a private session and I'll connect with you after I conclude with this. See, some parties have the tendency to go on for a very long time. They want to explain everything. All right. Now it does not look nice if we try to cut them off, because we would have already understood what is the gist of their problem. But if we try to, either interrupt or interfere, they might think the mediator is in a hurry. Now, at no point of time, a mediator should give the impression that the mediator wants to conclude quickly, whether it is haste or speed, we have to think of that. Okay. So, the person waiting in the waiting room, might not even come back and join the meeting again, because he will think, oh, I have already been waiting for 25 minutes and nothing is happening. So I might as well, disconnect. So leave the meeting. Now, again, to reconnect with that person becomes difficult. The other most important aspect, what we find is the advocates who represent the parties, whether they are also participating. See, it is not just between the parties. As I said, because it is still a court, a next court referred mediation, the participation of advocates becomes very essential. Now, many a times the advocates might say, sorry, I have got some matters in the court. I cannot join this meeting. So you go ahead and do whatever you want. Per contra, in a physical mediation, the advocate advocates would make an attempt to come in person or send some other advocate from the office to represent the parties. Now, there what happens? The parties have that confidence. See, my advocate is with me. My advocate will guide me. Now, many a times that is absent on a virtual platform. So that's another major task that we find, how to circumvent this problem. Because in that scenario, what happens? We have to connect with all the parties, and some of the parties or the advocates might sit in a park or sit in the car and try to connect. Okay, so they may not have a very good internet facility in a public place. Now that is another difficulty which is very problematic in arriving at a meaningful process. That is one of the major things that we have always faced. But having said that, we can still make some progress. It is not, see, anything above zero is always better. Instead of no mediation at all, some mediation virtually also is good because we can feel the pulse as to what the parties want. Whether it would be beneficial to tell them that, all right, we have done so much on virtual platform, then why don't you now come physically and let us take it forward? Now, that advantage will also be there. So it has its pros and cons, but at the end of the day, we are finding that connecting with the people in some mode is better than not connecting at all. So that's how
Right.
I would put it.
Right, sir. Because when the parties come to the center, they feel like they're going to the professional place. So they feel that we
Yes,
have to dress up accordingly. But most of the people have this
correct.
mindset, oh, it is from home. We can be in our own comfort and attend meetings. But at the end of
Yeah,
the day,
yeah,
online mediation is also formal proceedings. So it's a very
correct.
important. Parties keep the decorum and respect the mediator so we can have the formal discussion there. Yes, sir. So before we conclude,
True, true. Very
yes,
true.
yes. So before we
Hmm.
conclude, what could be the
Please.
piece of advice which you would like to give to our young lawyers?
That's a very pertinent, apt, relevant question. See, the law has evolved. The practice has grown in different vistas. Okay. It is no longer, you choose between civil or criminal side. So, in the days which have come now, you can specialize in, dispute resolution mechanisms. So you can take it up as a profession by itself. Even the Mediation Act does not particularly define what is the qualification for a mediator. Nowhere does it say the person should be an advocate or a retired judge or a sitting judge. So the younger generation of lawyers who are coming out, they can start getting trained in the concept of mediation or any alternative dispute. Arbitration is also a very big way of conflict resolution. So also is negotiation. There are skilled negotiators. Their job is only to negotiate. Okay, so any one of these, if you take up, whether it is arbitration or what you call negotiation or mediation, any one of them, you can become a specialist in that. Just as in the medical profession we have a specialized and a super specialized people, we can become like that. So there is a growing demand for the younger breed of advocates passing out to concentrate on how best they can utilize their resources to become good mediators, good arbitrators, good negotiators, and definitely it will pay off in the long run. There are specialized courses for this. As a matter of, we also give training to students in mediation process. So they are equipped with the additional knowledge of how mediation process works. Now, that is definitely a plus point on their CV, and definitely as a profession by itself, it is good because before long, the mediation rules would be framed, and it would be very, much in demand. Because see, every situation or a problem does not or may not need somebody who has got decades of experience. Because see what happens, mediation should also be cost effective. Just like arbitration also has to be cost effective. So what happens is they would say, oh, say my problem is not of such a nature that it involves very complex legal issues. So even a youngster who has the ability to do it is preferred. Now, when the costs come down, the demand for younger mediators, I would say, please concentrate on these various other mechanisms other than only either litigation or corporate practice and any other branch, whether it's teaching or anything it could be. But at the end of the day, certainly knowledge of mediation or any other mode of resolution would be an added advantage, and it should be pursued now, you know, not after so coming out and 5 years later you say, okay, now what do I do? Because you'll be, there will be others already who have overtaken you in the profession. So that state should not come. So
Yes.
certainly they should concentrate on this.
Yes, sir. That's what our motive is at Me-Arcone doing. We are trying to call experts like you so we can motivate the audience that, and especially the law students that just don't stick to the civil and criminal. There are a lot of fields of law. Law is evolving day by day. Now cyber laws are coming. ADR is also evolving. So that's actually a good advice for the young
Yes,
lawyers, sir. Thank you so much for joining us today. And
thank
your
you.
knowledge
Please.
and your experience gave us a comprehensive knowledge about online mediation, and I hope so our audience will be benefited out of it. So, and thank you to our
Yes.
audience
I
for
also wish it.
yes, yes, sir. Thank you so much. And thank you to our audience who keep on encouraging us to keep such podcasts, and we would be continuing doing the same. Thank you so much joining us, sir, today. Thank you so much. So, okay, sir.
Thank you. Thank you.
Yes, sir.